Behavior Analysis Regulatory Board meeting is convening at 9:09 a.m. as July 17, 2020 at the Health Licensing Office in Salem, Oregon. I will now call roll. Megan John, here. Brenna Lagarde. Sorry, here. Brad Hendershot.
I'm here.
Samantha Farnham. Here. Corey Stunk. Here. Marie McMahon. McMahon, here. Thank you, man. I think I know that's not right. Jennifer White. Here. Great. Members, during the course of the meeting, please wait to speak until recognized by the chair. Once you have been recognized, please state your last name. Audience members are asked to sign in on the attendance roster. Public interested parties' feedback may be heard during the public interested parties' feedback period if indicated on the agenda. Everyone is asked to use appropriate language, manners, and protocols when conducting board business. This meeting is called to order.
Okay, this is Sylvie. Thank you, Megan. Before we go into item number 1, which is approval of the agenda, I would like to make a couple changes to it. We can delete item number 7 and item number 8. We originally had item number 7 on there because we thought that we were going to have a case that we were ready for you guys to review and give us some guidance on. However, it's not ready yet, and so there's no need to have item number 7 and number 8. That being said, somebody, when I get done talking, needs to make a motion to adopt the amended agenda. With that, also be understanding that there may be a meeting between now and your January 22nd meeting that we need to call together to have you guys review the case. So we'll email you if that gets to the point where we need to have a meeting, but other than that, if someone could make a motion to approve the amended agenda.
This is McMahon. I move to approve the amended agenda. This is John.
I second.
I heard Brenna first, or loudest, so Brenna seconded. Sorry. And then Megan, you need to call a roll.
A motion has been made. I'll call the roll. Sorry. Megan John, yay. Brenna Lagarde, yay. Brad Hendershot,
Yay.
Samantha Parnham, yay. Corey Stump, yay. Marie McMahon, aye, yay. Jennifer White, yay.
Perfect. Okay, this is Sylvie again. Again, in this weird, awkward situation where everybody's on the phone, so normally we get to see each other. However, we do have a new board member who's on the phone, and so I'd still like to do some introductions. We won't necessarily do the office introductions around here, but mainly for you guys on the phone. So, Jennifer, if you could kind of give the board a little bit of information about who you are and why you're interested in this board, and then I'll go through all the other board members once you're done.
Hi, I'm Jennifer White, and I'm a board-certified behavior analyst and licensed behavior analyst. I've worked in the field for about 11 years. I work with Invo Progressives, it's a contracting company, and I'm contracted with Portland Public Schools as a behavior analyst. I also am an adjunct instructor with Oregon Institute of Technology for their Applied Behavior Analysis program. And I've served on the board for ARABA. I'm interested in this board because our field is growing so much here in Oregon, and I just want to be a part of that growth and making sure that we are continuing our ethical practices and serving our clients with the best possible treatment.
Perfect. Thank you, Jennifer. Megan, you want to introduce yourself to, obviously, mainly to Jennifer, but to everybody else also?
Sure. I'm Megan Johns. I have been working with individuals with disabilities for the last 10 years. I currently am employed with Positive Behavior Supports as a board-certified behavior analyst there. I also have my own business where I'm working on social skills groups with children and I've been on the board for over a year, I think.
Thanks, Megan. Brenna, you want to go ahead?
Sure. I'm the parent member, so I'm not a BCBA. I've got a now 12-year-old with autism who's been receiving ABA for 7-ish years now. I'm a lawyer. I do intellectual property law, and then I've also represented and currently representing a few kids and families in conflict with the school district over, mostly disability sorts of things. And I think that's about, I've been on the board forever. This is my second stint, so 5 years, 4 years? I don't know.
Thanks, Brenna. Brad, do you want to introduce yourself?
Hi, my name is Brad Hendershot. I've been on the board for a couple of years now, and by background, I'm a speech-language pathologist and licensed autism specialist, and I currently am an administrator with Oregon's regional programs that serves children with autism and low-incidence disabilities, and pleased to welcome you to the board.
Thanks, Brad. Samantha?
Sure. Hi, I'm Samantha Parnham. I'm a BCBA here in Salem. I am the owner and chief clinical officer of Adventures with Autism. I'm also now adjunct faculty at Capella. This is only my second board meeting, so I still don't know what I'm doing. And I'm super excited. I wish we could be there in person, but it's nice to meet you.
Thanks, Samantha. Corey?
Hi, Jenny. This is Corey Stump. I am a BCBA here in the Portland area for Footprints, Behavior Interventions. I have served on the board for about 6 months, so I'm almost as brand new as you are. I also serve on the Oregon Commission for Autism Spectrum Disorder, and I also teach ABA down at Oregon State University.
Thanks, Corey. Marie?
Yes, I'm Marie McMahon. I'm a licensed psychologist, and I work over at Providence Child Development Institute doing evaluations and treatment for kiddos with autism. And my early background 20 years ago is doing ABA. So I'm happy to be part of this group. This is my second board meeting.
Thanks, Marie. So we got a lot of newbies on there, which leads us right into our next things on our agenda. Well, actually, we got one before that, but so we need to work on proving the meeting dates for 2021, and then chair and vice chair for 2021. First off, we'll do the meeting dates. We have suggested January 22nd and July 16th, both starting at 9 a.m. If either of those dates do not work, I do have a calendar that we can look and pick different dates. We could always change it later if we need to. Does anybody have any concerns with either of those two dates?
Sorry, so you cut out on mine. This is Brenna. What were the dates again?
January 22nd and July 16th.
That's what I thought you said. Okay, those are fine.
And if nobody has any issues or concerns with those dates, we need to make a motion and a second to approve them and then do the roll call.
This is McMahon. I make a motion to approve the dates.
This is Legard, seconded.
Megan Johns, yay. Brenna Legard, yay. Brad Hendershot,
Yay.
Samantha Parnham, yay. Corey Stump, yay. Marie McMahon, yay. Jennifer White, yay.
Perfect. Good job, you guys. So next item is the 21 chair and vice chair. So currently Megan is chair. That's the reason she's attempting to lead this meeting with a phone. And Brenna is vice chair, which just means if for some reason Megan cannot run the meeting, then Brenna would. You need to vote for 2021 chair and vice chair. You can either keep Megan and Brenna in the positions they are. You might want to ask them if they're okay with that. Or you could select new people, but you've got a lot of brand new people to the board, so they may not feel comfortable with that. But you guys can discuss it.
Are you guys comfortable with staying where you're at? This is McMahon.
Legar, it's fine with me.
This is Megan. That's okay with me unless anybody wants to be the chair. I agree, Megan. You got this. This is Corey's son.
This is McMahon. I move to approve.
Well, so you want to word it to where you make a motion to have Megan continue serving as chair and Brenna to continue serving as vice chair. And now you can say so moved.
So moved.
Then if somebody wants to second it.
This is Corey Semple, second.
A motion has been made. I'll call the roll. Megan Johns, yay. Brenna Lagarde, yay. Brad Hendershot,
Yay.
Samantha Parnham, yay. Corey Stump,
Yay.
Maria McMahon, yay. And Jennifer White, yay.
All right, good job, you guys. So we're now on item number 4 of the agenda. So director's report. I want to kind of give you guys this update of how the state is the state of the state. So as most of you probably already know, that the governor has shut down the state offices. Currently, we are shut down at a minimum until August 31st, which means that we are not, because normally we are open to the public on a walk-in basis, which means now we are not. So people are still allowed to come into the office for testing, however, they have to make an appointment. And we have to abide by all the spacing rules, which means our number of test stations that we're allowed to use is very, very limited. So we are mainly doing everything via over the phone and online and through the mail because of that. If the cases do not improve and the governor shuts the state down for longer, then we will be closed even longer. That also means that all board meetings must be done via the phone. So again, it's not the most convenient, but that is how we have to operate until she allows us to open back up. Also with that is the lack of funding that will be coming in to the state due to obviously lots of people not working, the amount of money going out for unemployment benefits, and all that stuff. So she has also required all of us state offices and agencies to be in a hiring freeze. So that means that we have several positions that are vacant, and we're not allowed to fill them, which is hard because we actually have more work to do now during COVID than we did prior to, because I know it doesn't necessarily affect you guys, but cosmetology is one of our big boards, and we need to do inspections and help educate on the social distancing and the face coverings and all that stuff. And we have only 3 of our 5 inspector positions filled. So we have 3 people trying to do the work of 5 with additional workload added. So it's putting quite a strain on the office. We also are down a couple investigators, several licensing staff, and we're not allowed to fill. So it's just everybody's trying to do more work with less people. So it's struggling and making people a little tired, I do believe, but we're all trying to get through the pandemic. One thing that you will note is that Maria Gutierrez used to be the one who would send you a lot of emails and communicate with you regarding attendance and all that kind of stuff. Maria has taken over a new position, And so you will start, we're in the middle of transitioning from Maria to an April Strobel, so you'll start getting emails from April instead of Maria. Fleming, sorry, she got married. I keep forgetting, sorry. Fleming, and she's laughing at me. So just so you know, those two are working on switching all the duties over. But that's all I had for the director's report. Does anybody have any comments or questions? All right. We will move right along to the licensing and fiscal statistics reports. So, and you should have gotten a packet, and I can go through these in detail. I know we have several new people on the phone who have probably not seen these reports before. The first one shows licenses issued and then renewals processed. So on the top, it will break out by quarters. And so for those of you who are not in state government, the fiscal year is a kind of a little odd thing. So when you look at fiscal year 2020, quarter one, that is actually July, August, and September of 2019. So our years are different than in the calendar year, so it gets it all messed up. So we're currently in quarter four, but you can see there, the top half of that chart is licenses issued, the bottom half is renewals processed. Anybody have any questions on that? And I know this is new for some of you. All right, you guys are an easy crowd. Okay, next slide shows as of June 26th, the average number for that quarter of licensees. So you have the top at 1,653. And then the 294 and the 21. And then down below just shows the trend increase. Any questions on that? Okay, I will keep moving. Next slide just shows the active behavior analysts broken out by age and gender. So the majority of the licensees are between the age of 26 and 41. Next slide is the age and gender for assistant behavior analysts. And you can see there's not as many assistants there. Then the next slide, which is the interesting one, is the interventionists. So that one shows the age, same data, but age and gender, and you can see that a vast majority of the interventionists are between the age of 18 and 25. So hopefully those eventually will then go to the previous slide, hopefully become a assistant behavior analyst, and then eventually move up to a behavior analyst, but we'll see. But that's nice to have a lot of young individuals coming in, but I also understand that a lot of young individuals, this is may not be a permanent job for them. But
this is McMahon. I wonder, with diversity so highlighted right now, does the board have any information regarding the diversity of, interventionists, BCDAs, and assistant BCDAs?
So this is Sylvia. Are you asking what nationality they have, or are you talking about the gender? Because we have male, female, and then you don't have to answer that question.
I'm wondering about race.
So we asked that question on the application. Mm-hmm. However, it's a voluntary question, so they do not have to answer it. We can get you that information if that's something that you're interested in. But again, it's only as good as the applicants fill it out, because again, they're not required to fill it out.
Sure. Yeah, I would love to have some of that information. I feel like it's definitely relevant to the current conversation.
Sure. We'll get that information. Yep.
Thank you.
You're welcome. And you want it just for the interventionist?
I'm actually, I think just for the group at large. I'm curious for people who, understanding that not everyone may answer that question.
Sure.
I'd be curious to know what the makeup is generally of people providing services.
Right, so we'll do it for all active licenses, and then we will be able to tell you how many did not answer the question. So it'll say how many didn't answer, and then what group they picked, and they're allowed to pick more than one, so just so you know.
Can I ask a clarifying
Okay.
question? Hi,
Thank
Board.
you.
This is Ann. I wanted to ask a clarifying question. Do you want the racial reports to be broken out by licensee, or can we blend them all together?
It's fine for me to be blended together.
Okay.
Yeah, I got what you mean. We'll talk about it when we're done, and we'll get you that information.
Okay.
Thank you.
No problem. Any other questions before I move on? Okay, so I'm on this slide that shows the pie chart. So again, this is as of June 26th, which is when the reports were ran. It just shows you at that day that those reports were ran, how many active licenses there were by the 3 different groups. So the 16,003 interventionists, I do believe, is way more than you guys ever assumed there was going to be. Way back in the beginning when we brought this into the health licensing office. And then the next slide is the financials. So that's broken out by, again, fiscal year, which if you look at the details of it, you'll see the weird July 1 through June 30th calendar, which is our year. And then down along the bottom, so I'll go down along the bottom a little bit in detail. So on the very bottom, it'll show shared assessment, small board, examination, and inspections. And then you go across and it gives different percentages. So for shared assessment would be anything that you share along with all the other, so there's the other 15 boards and programs that are with us, there's 16 total. Of that, so like rent would be one that you would have to share. My salary would be one that you all have to share. So those shared assessments are things that everybody touches. You pay, well currently you're in the last column, you pay 0.5% of that. And then the small board assessment, so that we have, small board assessment is everybody except for cosmetology. And of that, you guys pay 5.113%. We reevaluate those percentages every year, every July, our weird fiscal year. So every July 1, those percentages get changed. The reason for those changes is that the office is constantly changing. So adding in a new board or program then splits out those percentages even more. So if there's 2 years ago, there were only... Well, 2 years ago there was 14 boards and programs, now there's 16 boards and programs. So every time something new gets added, the percentages get recalculated. So, and then it's also based on how many licensees are in each board or program. So cosmetology pays a very large portion of the shared assessment. They're roughly around, I think, 90% of that. The other 10% then is divvied out between the small boards. So that's kind of how that works. And that means that anything that is an indirect cost, anything that can't be tied to a specific event or a specific board, is allocated through our internal cost allocation based on these percentages, which is, like I said, rent, our utilities, anything like that goes shared out. When we have something that's very specific to this board, then it obviously gets paid directly by this board. Does that make sense?
This is McMahon. I think I confused myself with the fiscal year. So we're currently, July in 2019 to now is the 2020 fiscal year, or we're not yet in the 2020 fiscal year?
You are correct. So,
okay.
So, there's so many details to this that I try not to get into the details because statewide accounting just gets really complicated. So, but
it starts so starting July 19th this year, it'll be the 2021 fiscal year. Is that right?
So the starting, like as in 16, today's the 16th, right? 17. So as 17 days ago, we started the 2021 year. So,
okay, got it.
Yes, so the 2020 year ended on June 30th, so 18 days ago.
Okay.
But this report was run in June, so we don't have obviously our 21 year just started.
Of course.
Does that make
All
sense?
right,
Yeah,
thank
it gets really confusing, which is why I try not to go into too much details about how accounting with the state government works, because it just gets people even more confused. And just to clarify also, that all the revenue that any of your licensees pay, every board and program has a separate fund. So all the revenue that your licensees pay in goes into that fund, and then all the expenses that are associated with your board comes out of that fund. And then the office as a whole doesn't have any money per se, it's all the boards that are underneath of it. That kind of makes sense? Okay?
Yes, thank you.
Yeah. And I know that several of you are new, but you're welcome to ask any questions. I'm a pretty transparent kind of person, and I like everything here to be transparent. And I'll try and answer any questions you have. But if nobody has any questions on those reports that I just talked about, we will move on. Does anybody have any questions? Man, you guys are easy. We're going to get done way early. So we are on the regulatory report. Bob is here in the office with me. We haven't figured out our phone. For some reason, the attached speakers are not working, so it's really hard for us to stay 6 feet away from each other because we all have to share the same speaker. So he's going to scoot over, and he's going to talk a little bit about the regulatory report.
Hi, good morning, everybody. So, it's going to be a quick report because not a lot of information I can share with the public in attendance. But in the 17-19 biennium, we had a total of 13 complaints. 3 of those remain open, and we are hoping to get these to you between now and your first board meeting of next year. And then in the current biennium, we've had a total of 19 complaints received, and 12 of those remain open. Any questions? Awesome.
So, and I want to clarify a little bit too, so especially for Jennifer and Corey and Marie, if we were to have an executive session, which hopefully we'll have one soon for you to review some cases, then we'll get into more details of what these cases are and how far along they are in the process. As you know, our conversations right now are all public record. And so we don't talk about the specifics of a case unless we're in executive session. So we'll give you those details when we have an executive session. So I know that that's kind of a very broad report from Bob, and it doesn't answer a lot of questions, especially for when you're new. But we'll get into that details at a different time. Okay?
Thank you.
No problem. Okay, so now we're on policy report, and Ann's microphone does work, so she can stay at her desk. But Ann, if you want to go into your policy report.
Sure. Good morning, Chair and members of the board. At our last meeting, there was some discussion about policies around the use of restraints. And from that conversation, the board decided that everybody would go back to their own areas of expertise and come up with information that perhaps could guide our rulemaking if you choose to open rules around the use of restraints when appropriate and how to do it. I sent out reminders. I haven't received anything from anyone on the board. So I'm sort of dead in the water. So if this is something that you guys want to discuss further, or if you have something that you didn't share with me, now would be the time to discuss it.
This is Megan Johns, and Brad sent something out shortly after our last meeting that was pretty comprehensive.
Brad, do you remember what you sent?
Was it a link to the Senate bill that was passed?
Oh, that's in here.
That's in there.
Yeah.
No, I feel like I remember seeing something that was your restraint policy with your company or something like that.
Oh, could it? Well, I don't. My memory's not serving me well, but I wonder if I sent something that was PPS's restraint and seclusion policy, because every district has to have one. That kind of defines the parameters and circumstances under which restraint and seclusion are permitted. And of course, it's to protect the safety of the child or safety of other individuals in kind of an immediate situation.
Yeah, I mean, I remember seeing something.
Oh, go ahead, I'm sorry. Go ahead.
No, it's okay. I just remember seeing something and I thought it was from you. I could be mistaken. I'm trying to go through my emails and find it.
If I missed it, I apologize. It seems like we've all been kind of in a strange bubble right now. But, yeah.
I want to understand what we're talking about here. If the board were to initiate the rulemaking process, it would be to potentially develop some language that would, it would regulate the use of licensees in terms of their use of restraint, and that there would be, and then if licensees violated that, there would be some sort of penalty. Like, I'm trying to understand what it would look like if we were to pursue this. And I'm also kind of wondering if other states have similarly kind of self-regulated restraint among behavior analysts and interventionists.
So this is Brenna. Yeah, that's basically the idea. I mean, so our ethical rules for our regulated individuals are basically the BACB's Code of Ethics with a couple of relevant provisions excluded, and there isn't really anything in that code that says you can't use restraint as as an aversive or as anything other than something you actually need to do to protect the kid or protect other health or safety. And so like at this point, the use of restraint, I don't want to speak out of turn. The thinking was that if the rules spelled out what we expect, then it would be easier for investigators to identify problematic conduct.
Right.
It doesn't feel like something we really need to say, but on the other hand, it seems like maybe it's something we need to say. And so, the thinking is that this would make it easier for the people doing investigations to figure out what they should be concerned about and what isn't as concerning. And I don't know. I mean, one of the things we're going to do is try to figure out what other states are doing, and I dropped the ball too. Everything is so overwhelming right now. I asked Building Bridges, which is the organization that provides therapy to my son right now, to tell me about their restraint policy, and it was comprehensive and pretty nuanced, and it wasn't something that looked like it would really easily lend itself to an ethical rule, but I still think it's important for us to think about this.
I agree.
This is McMahon. I had research that ended up being more about kind of the effects, so there's kind of a review exploring the physical and psychological harms about using restraint, like for mental health inpatient settings. Some of it is with people with intellectual disabilities, but I wasn't finding anything policy specific. I'm happy to forward on the articles that we were able to locate. If people find that be helpful, but I don't have like a policy per se.
This is Samantha Parnham.
Go ahead.
I was just going to say, I can send over our restraint and seclusion policy that we have internally. It's just adapted from ABAI. So that might help guide it, but I think we'll probably run into the same thing as we did with the one you looked at, Brenna, because I'm not sure how easily it's going to lend itself to rules, but I can certainly forward it over.
So this,
I mean, I think even if, like, I don't know if this is legally permissible actually, but I think even, if investigators had an idea of what it should look like, it might be easier to figure out what it shouldn't look like. I mean, ideally the rules would say something like, you can use restraint when you don't have any other options and somebody's, against safety or life is in, reasonable danger, but you can't use restraint to, like, as an aversive or to achieve a treatment goal. Something like that.
so this is Sylvie. I'm sorry to interrupt, but I want to make sure that it's very clear for all of you who have something to, quote, send. Make sure and send that to Ann. Do not send it to each other. Do not email each other because you are board members and that would be board business. But make sure and email it to Ann, and then Ann can email it out to all board members so everybody has the same thing. But just interjecting there. And another food for thought that you guys could think about is drafting a rule that says all licensees, you can name them out separately if you want to have a restraint policy in place and must provide the parents with said policy, because then if we had a complaint, we could go in and say, where's your policy and did you follow your own policy? But that's food for thought.
Ooh. Hi, Sylvie. Thanks for taking that.
Yeah, this is Samantha Parnham. I was just thinking that because we, like, our internal policies and procedures have lots of, obviously, paperwork that goes along with them. So if it just said kind of have your own internal policy and procedure, but if someone asks, you need to be able to provide us with all of the backup information about who was there, how you got there, why you did what you did, how parents were debriefed, et cetera, et cetera.
Well, this is Sylvie. I think that it's hard to comprehend the fact that not everybody works in the same environment. So you kind of have to write the rules where it will address every single scenario. So if this company says, well, we have our own policy of this, and then this company says, well, we have this policy, as long as your policy covers A, B, and C, then you can have your own policy. But everybody has to have a policy and make sure the parents have it or whatever. And that's how you can kind of write it. Because if you start getting down to the policy must have this, this, and this, then you're going to want to be real careful and write that for all situations. So that's kind of sometimes when it gets a little complicated. And I do believe, this is Sylvia again, I do believe that there was also some discussion about some restraints that were used and whether or not, I'm trying to remember, wasn't it? What was lasting effects and all that kind of stuff. So I know that this has been a hot topic, I think, for a while. And so, but we can start drafting some language if that's where you guys are wanting to go, more of the broad, but you give us some direction.
This is Brenna. Yeah, there was an incident we talked about last meeting that, at least I found pretty disturbing, that, was the impetus of thinking that we actually needed to spell this out. And I like the idea of just requiring them to have a policy, because then shops can educate their people about their policy. And educate parents about what to expect and, how to figure out when things weren't followed and all of that. So I really do like the approach, and I would, speaking personally, like you to work up some language.
This is Brad. I also agree. I think it would be a good use of the board's time. And I mean, I guess the question I am pondering is, sometimes, are we solving a problem that does not or may not exist? My own internal check is I think we're not doing that. I think that it is worthwhile. You know what I'm trying to say, though? You don't want to have prescriptions for, issues that aren't, real. But my sense is that it's in the interest of children and families and professionals to have some language. So just process-wise, what would be the next step? Would it be the board would vote on whether or not to open the rulemaking process on this topic? Is that kind of how it would work?
Brad, yes. So I'll get into the details once we hear from everybody on kind of, so we've heard from you and Brenna about, that bigger picture, but yes, I'll get into the details of how this will actually work. No, you're fine. Sometimes we just get too far ahead of ourselves and not everybody gets a chance to speak. So let's go through everybody and kind of listen to your thoughts on the big picture about, you have a policy in place, you share said policy, you must maintain policy, that kind of thing. So let's go through. Samantha, what are your thoughts on that?
I agree. I just sent over what we have too, and so you guys have that. But yeah, I think that's probably the best way to go about it.
Okay. Corey, what are your thoughts?
Well, looking through the Senate bill that we have here, I think using this as, this is basically our state definition, and kind of using this as our backbone moving forward, I think is something that we just kind of want to continue to look at. But I think moving forward, we're going to want to continue to look at this more specifically as it relates to services, specifically within each program. I know specifically some programs are completely hands-off, where some programs are more intensive behaviorally, and so I think each agency would have some amount of responsibility to identify to families at the onset of services what is their specific role when it comes to providing restraint training to their staff, but also how are they, where are they in regards to, do they provide restraints, do they not provide restraints? And that way families know from the get-go, this is something that is a possibility for my child, or is this something this is not a possibility for my child. It's just my experience. I think families having that proactive information is really important.
Very true. And that's kind of why I was thinking if we say you must have a policy on restraints, and just to clarify, this Senate Bill 963 that's in your materials, that very specific is to education, so this is pertaining to schools, and as we know, not all ABA is done in schools. Obviously, it is done in schools, but this is their statute. This is great reference for information and definitions, and so that's why we included it. But I think that's why we would say that you must have a policy in place about, and that's where you guys can start tweaking the words, but must have a policy in place that talks about training hours and when you do and don't use restraints and all that stuff. And then we're not saying that you have to have a policy for use restraints. We're just saying you have to have a policy if you do. So that was kind of my thought, and hopefully everybody's still on the same page. But Marie, what are your thoughts?
My thoughts are similar to everyone else. I think that it's necessary to say that there's a policy and that should be guided in some way, that people can kind of explain that reasoning, to help people know if they're kind of following their own rules.
Exactly, and it will also give us as the office a little bit of teeth in response to somebody who didn't follow the rule, follow their policy. If we were to get a complaint from a parent and go to do an investigation, then well, here's your policy. Why didn't you follow it? That's but then it would help us a little bit more in the investigation process too. So, Jennifer, what are your thoughts?
I agree. I think that that's a really good idea. I was wondering, though, is it possible to hear more information about the case that was discussed last meeting that kind of sparked the discussion, just for background information?
We cannot talk about the specifics of the case unless we're in an executive session. So one of the things that we can talk in more generics, but not specifics. But it was where restraints were used. The investigator felt that they were used inappropriately and felt that there was not clear regulations on what that individual should or should not have done. And so I can't get into a lot of the details, which I know is frustrating, but because we're in public session. But that's the gist of it. And I think our goal is just to make sure that it's clear on how you use, the intent here is when you use restraints, when you should or shouldn't, how you should or shouldn't, and then making sure that you're thinking about the consequences of people who are different on the spectrum, who may react to it in different ways. And so, and Brenna, I don't know if you want to add to that, but I know you were around through that whole process, and just don't get into the specifics of the case, but that bigger picture.
Yeah, I mean, so the incident in question was the use of a fairly prolonged period of, pretty intimate restraint to obtain compliance, not to, again, protect anybody. And to the extent that technique wasn't spelled out in the treatment plan, it seemed to be the plan, we shall use restraint to obtain compliance with this thing that we're doing. I think that kind of thing, at least anecdotally, I think there are vestiges of that in the practice. It's important. I think it's important that we be proactive with respect to these sorts of things because I think ABA is a practice that has changed a lot over the last decades. And I think especially the use of adversives and other things. I think old ABA used to use those quite a bit, or at least some practitioners used to them quite a bit, and I think that's part of why the therapy has a pretty, negative reputation in some circles. I think, there are some people who really have been harmed, years and years ago, and I think the profession has changed, but maybe it hasn't changed as much as we think it has, and, I think this is harmful, and this is, squarely within our duty to the public to make sure that, this isn't something that people are doing.
This is Jennifer White. Thanks so much for giving me just kind of the background on it. I do agree it's something that should be addressed because it's a serious issue. And I do like the idea of kind of that agency or setting specific policies regarding that.
So did somebody just log in? Did somebody just call into the meeting? Okay, so the phone beeped. We lost somebody then. So I'm going to do a roll call real quick, just to figure out what's going on. Megan, are you still on the phone?
Yes.
Brenna?
Yep.
Brad? Ooh, we might have lost Brad. Samantha?
Yep.
Corey?
Here.
Marie?
Here.
And Jennifer?
Here.
Okay, so Brad must have disconnected, so it'll make another noise when he logs back on. But Megan, what are your thoughts on the rule regarding restraints?
I think it would be a wonderful idea to provide, help with when we review these cases, as well as some unification across ABA agencies across the state, even if it's just their own. But I feel like they should have a restraint policy, even if, let's say they don't use restraints in that setting, then their restraint policy should say we do not use restraints under any circumstances. You know what I mean? I feel like it still needs to be, they still need to have that.
Absolutely.
In writing, you know what I mean?
Absolutely, 100%. Yeah.
Because I feel like too often, even if a company has a policy when there's organizations that are doing only home and community based, there's sometimes some free agents. And so having it, even saying hey, we don't use any, can help accommodate for those too.
100%, absolutely. So it sounds like everybody is on board with this. And now that, of course, Brad asked the question and he's not on the phone. In your packet, right past that bill, so we inserted that bill so that you could look at it, and but in your packet, right past that is an issue statement and a rules schedule. So we have between, and hopefully everybody's okay with this rule schedule because the whole COVID-19 stuff, but at your January 22nd board meeting, it was when you will review and adopt proposed rules, which gives us between now and then time to draft up something that, based on your conversations today, and also will include Heather, which is our attorney, in reviewing the verbiage. And between now and then, please send Ann Thompson anything and everything you could remotely think that she may want to look at. And then she'll get that out to all of you. And then we'll draft, like I said, we'll draft the rule, and you guys will tweak it and finalize the proposed rule January 22nd. Then it will go out for public comment, and then you will meet and adopt permanent rules. So that's the game plan on how this will all work. And of course, Brad's not on the phone to listen to my answer. But if one of you or all of you are okay with that, then someone needs to make a motion to begin the rule writing process and adopt the rule schedule.
This is Brenna, so moved.
And a second?
I second the motion.
Okay, Marie did. Brad, did you just log back on?
I did. Sorry about that.
That's okay. I just answered your question about what's next. So I will get you up to speed real quick because they're going to ask you to vote on something. So at the January 22nd board meeting, which is when between now and then, we will draft up a proposed rule for you to start working on that January 22nd meeting. Between now and then, please email Ann anything and everything you want her to look at for this rule, whether it's your policy or anything that you have. And then at the January 22nd meeting, you guys will adopt proposed rules. You'll also tweak the verbiage that we come up with. We'll make sure the attorneys had a chance to review it too. And then it'll go out for public comment, and then the board will vote it permanent in July. So there's already been a motion and a second to adopt the rule, open the rulemaking process and adopt the rule schedule. And Brenna had made a first, and Marie had made a second, and now Megan is going to call roll. So now hopefully you feel comfortable voting. Go ahead, Megan.
A motion has been made. I'll call roll. Megan Johns, yay. Brenna Lagarde.
Yay.
Brad Hendershot.
Yay.
Samantha Parnham.
Yay.
Corey Stump.
Yay.
Marie McMahon. Yay. Jennifer White.
Yay.
All right, good job, you guys. We'll get working on that. Just like I said, reminder to send Ann anything and everything you can think of, even if it's not something that you think that is exactly like what we want, but even something remotely close. It just helps her get an idea of everything. We're going to move on. We are on item number 6. Megan, you do have a little script that you can read because we are on the public interested parties feedback, and I know it's a little awkward because the actual public is on the phone, but I have their names, so if you want to just basically read it and kind of reword it, but I'll call them off and they can talk.
Okay. At this time, the Behavior Analysis Regulatory Board will hear public interested parties' feedback. Members of the audience, please wait until you have been recognized. Once recognized, please state your name and affiliation to the board for record.
Perfect. Good one. Okay, so we have 2 public members on the phone. We have a Michelle and Paul. Paul also submitted written testimony, so hopefully you've had a chance to read that, but Paul is on the phone and he can summarize that for you or answer any questions you may have on that, and then also talk about anything else that he may want to talk about. Paul, are you on there?
Yes, I am. Thank you. Let me briefly first follow up on the previous conversation about seclusion and restraints. So that was something I testified about in the last board meeting. I think there were some questions here about what that was all about and how it got started. As I explained in the last board meeting, I was contacted by interested parties who were, I think, asking me for what I knew about current rules and statutes involving seclusion and restraints and regulation of ABA generally. They described several situations to me that they found concerning. So in one case, a young boy wanted to hold a book at a group setting and refused to put it down. The behavior analyst allegedly put the young boy in a headlock and pinned him against the wall. In another case, they described how a licensed behavior analyst twisted a young girl's arm behind her. And then in an additional case, they described a behavior analyst bear-hugging some children. And they described the physical appearance and sort of demeanor of the behavior analyst as demonstrating extreme anger while doing so. The issues that arose, so I was told that these issues were reported to DHS about a year ago now as potential child abuse, but the issues that came up were that DHS authority was unclear over behavior analysts because this is not child care and these were not school teachers. And so that is where I came to the board 6 months ago with a suggestion of doing rules, and I think the board may have heard other information as well that may have prompted the same discussion. So that was sort of the background that I had on it. It was just a lack of clarity. Your current rules, as you just discussed, points to the BACB rules. The BACB rules are extremely vague. And I'm looking at section 4.09, least restrictive procedures. Behavior analysts review and appraise restrictiveness of procedures and always recommend the least restrictive procedures likely to be effective. That's extremely vague. It does not give BCBA licensees much guidance on what they can and cannot do. It doesn't give your investigators much guidance on what to pursue. So I'm really glad that you decided to open rulemaking on it. I would like to be a part of that process for a Rules Advisory Committee when you get there. As a resource, I would encourage you to look at, I would point you to the Kennedy Krieger Neurobehavioral Institute in Baltimore, Maryland. They are an example of it.
Paul, sorry. Paul, can you email that to Ann, that company you just said?
Yes,
okay,
I will definitely do that. The reason I pointed out is they do make extensive use of restraints. And I think getting their input on what they do and what their procedures are could be helpful. That doesn't mean you'd want to follow what they do, but I think that would be an example of a highly respected institution that does use restraints, and that might give you a sense for what they consider appropriate and how they do it.
Perfect. Just send that, even if that's the name or whatever, to Ann, and Ann will, yeah. Perfect. Okay, go ahead.
Okay. Great. So then that does actually tie into the next comment, which is what my written comments were about, and that is some possible legislative concepts for the 2021 legislative session. The first one that I listed is the Autism Health Insurance Reform law that was passed in 2013 and amended in 2015. The insurance coverage provisions of that sunset in January of 2022. And I think the question that comes up is whether or not anything should be done to address that. As I wrote in the comment, we're not really following that statute. Currently insurance coverage for ABA is provided under Oregon's mental health parity statute, which is not going away. So it's an open question for what to do, and I've outlined three options. One is take the existing statute, delete the sunset clause, so it stays in forever, and just do nothing else. The problem with that's easy, but the problem is that there are a whole lot of provisions in that statute that the Department of Justice and Insurance Commissioner have found to violate federal law, such as age limits and visit limits on ABA, and a number of other provisions within it that are basically non-quantitative limitations that would violate the federal mental health parity statute. The second option would be do the law, but fix all of those things that violate with federal law. That would probably the best approach, but it would be a lot of work and could result in lots of discussions that could be challenging. And then the third option is basically do nothing at all and allow the bill to sunset and expire. That's obviously the easiest thing to do, since, and again, we'd be relying on the existing statutes that already cover it, but it sort of raises the question if that's the direction we want to go. So those are the three things that are on the table there. Let me just run through the other bits, and then I'd be happy to hear questions. The second category would be updating some regulatory issues involving licensed behavior analysts, and this is obviously closer to this board. There are a number of miscellaneous provisions in Oregon statute that should apply to behavior analysts but don't, simply because we overlooked it when we were creating the board. One of them is the statute on child abuse reporting. That statute has a very long and detailed list of exactly which licensed providers are required to report child abuse. Licensed behavior analysts are not on that list. So that raises ambiguity about whether or not they are actually required to report child abuse. The next one I have listed, there is a statute in Oregon that broadly allows any child starting at the age of 14 to seek mental health treatment on their own without parental consent. That applies to essentially every other form of mental health provider in the state except for licensed behavior analysts, which means a child could get ABA therapy now from a psychologist or a clinical social worker or an LPC. They just couldn't do it from one of your licensees. And it seems to make sense to sort of add your licensees into that for consistency. The third is gay conversion therapy. Several years ago, Oregon banned use of mental health care to use gay conversion therapy on minors. That statute again lists other mental health providers. It does not list your licensees. I think it is likely that there's a catch-all statement in there that would prohibit your licensees from doing gay conversion therapy, but it is not completely clear-cut, and I think it would be better to, for consistency, to add your licensees into that statute. And then the fourth one, this was identified by a Lewis and Clark law student who reached out to me about it, is a duty to report prohibited or unprofessional conduct, arrests, and convictions. Again, there's a statute that has a list of who needs to do that. It does include some other health licensing office licensees. It does not include your licensees. Generally, I think this is housekeeping. I think this should be straightforward. The two broad reasons to do this. One would be plug in the gaps. Obviously, we want your licensees reporting child abuse and doing the other things that are listed here. The second is, I think, just more broadly to reinforce the idea that your licensees are a part of the broad field of behavioral health providers in the state. In the short session in February, there were a number of bills that ultimately didn't pass that were broadly addressing strategic planning for behavioral health care in Oregon over the next decade. And yet none of them mentioned ABA or your licensees. And I think going forward, I would want to make sure that whenever anybody in Oregon is doing planning on behavioral health treatment, that your licensees are among the first that they think about as being a part of that process. And I think doing some of this basic work to sort of bring you back into the basic fold of how behavioral health care is regulated, I think will help to sort of remind people that you're here. The last thing I wanted to bring up is Practice Act. That was something we discussed in the last session. And in the last BARB meeting, it is already unlawful in Oregon to provide any sort of therapy as a treatment for any sort of mental health condition without a medical license. That's already law. It's a felony. The issue is that you just don't happen to have authority over the unlicensed practice when it comes to ABA. The Board of Psychology does have authority. They would really rather you take over that authority. As a practical matter, I don't think the 2021 session is the right time to address that. There's some ongoing litigation and other things that I think are best to play out first. I think it would be really helpful for this board to work with the Board of Psychology on a letter or some sort of bulletin just reminding people that it is unlawful to provide therapy services, including ABA, for the purpose of treating a mental health condition without a license. This does not apply to using ABA for a non-medical purpose, like teaching or criminal justice or engineering or management or anything like that. It only applies to the use of ABA for the purpose of treating a mental health condition. Then the last thing I just wanted to call your attention to, and I included it, since the last meeting, there were 2 U.S. District Court decisions relating to ABA that I think were interesting. In both cases, parents had sued school districts over access to an ABA therapist in school. The districts, one was Gresham-Barlow, one was Portland Public Schools, both moved for dismissal, saying that it was a matter for IDEA, the special ed law, instead of the Americans with Disabilities Act, and that the parents couldn't sue them until they had pursued administrative remedies first. In both cases, 2 different judges, federal judges, disagreed and said, no, this is in fact medical, this is about medical care, not education, and this is fair game to proceed under the Americans with Disabilities Act. And so those cases will be going forward. I think the trials are scheduled for early next year. That's what I had for public comment. Any questions, discussion?
This is Brad, Paul. I just wanted to thank you for an extremely substantive set of updates. That was remarkably helpful. Thank you.
Thanks. Any, I guess, in particular questions or thoughts about the proposed legislation for next year?
So this is Brenna. First of all, that SB 365 and the sunsetting provisions, I don't see any reason not to just let that puppy expire. Paul, do you disagree with that?
I'm mixed. There is a provision in there about providing AB services in home and community settings instead of just clinic settings. And if we lose this bill, then we fall back to mental health parity. And I think the question that I would want to ask some of my policy experts on would be, could an insurer say, look, we provide medical care in clinics. You want medical care, you come to a clinic. We do that for everything we do. And we'll totally provide ABA, but you got to come into a clinic for it.
So and I'll give the board a little more background maybe. This is Brenna again. So SB 365 when was it passed, Paul? It was 2012? When did we do that?
2013.
2013. So at that point, there was no insurance coverage in Oregon for ABA therapy. And Paul had been working on a bill for years and years and years. And then I swooped in for the easy part at the end. It set up the bill set up the BARB, and it provided for insurance coverage for ABA therapy, and then it included a bunch of compromise provisions so that we could get something that would require coverage, thinking that if we could get them to cover something, then we could leverage existing law to get them to cover everything. We just had to get our toes in the door. And so the toes in the door provisions were, I mean, they're icky, frankly. I still, years and years later, they still kind of turn my stomach a little bit. But I mean, there's an age cap. Like, insurance companies weren't obligated to pay for ABA therapy for anybody over age 9, I think, and they didn't have to cover more than 25 hours a week, and some other things like that, that the insurance companies needed, they demanded of us in order to cover anything at all. And so after we got that bill passed, we sued my family was lead plaintiff in a lawsuit against Providence Health Insurance. And the point of that lawsuit was to make the case that the Federal Mental Health Parity Act and the State Mental Health Parity Act already required coverage for ABA therapy because it's mental health care. And so insurance companies really couldn't deny coverage. And we won. And then after we won, the insurance division issued a bulletin saying, what the judge said, only applying it to all the insurance companies in the state. And, and then they had to grapple with these quantitative and qualitative limits that we put in this bill by way of this icky compromise. And they kind of came up with a sort of, difficult explanation that, those are really floors, not ceilings, and we all kind of, let it go. And then those provisions of the bill have been ignored ever since. And that's much of what we're talking about allowing to just expire, because the Federal Mental Health Parity Act and the State Mental Health Parity Act, as Paul points out, are not going anywhere. And they really provide the insurance coverage. And the other things that have changed since then, right, is in the post-ACA world, most insurance coverage is now, like the group plans are becoming, less and less common, right, post-ACA. So a lot of health insurer, or a lot of like employer health insurance is no longer group care. And so I don't even know, Paul, do you know if SB 365 even applies? I don't think it does.
It would not. It would apply to a real insurance plan, but I think what you're getting at is that most people don't actually have insurance. They have an ERISA self-funded plan where they're insured for medical bills out of pocket and hires an insurance company to process the paper. So it doesn't apply to them.
So as a practical matter, the number of plans that are actually affected by SB 365 in that way is diminishing and will continue to diminish, given the world and all of that. And so the thing in the bill that seems like it's still important is the bill said, that care can be provided in community settings. It's not restricted to clinics, because at that point, insurance companies were adopting all kinds of interesting ways to restrict when and how care could happen. And, they seem to be, like, I haven't heard a consumer complain about that kind of insurance decision in a long time. Like, have you, Paul?
I got a call a week ago. This is not a state-regulated plan, but it was somebody who has an outright exclusion for ABA in their plan. And it's a plan, it's a United Healthcare plan that is currently being litigated already. So he has that's not about where services, just say we won't do it under any circumstances. There was another decision some friends of mine got on Tuesday at the Ninth Circuit that is related under Section 1557 of the ACA. Their lawsuit was about hearing loss. Their Kaiser Health plan basically said, look, we'll do a cochlear implant, but we're not doing anything else for hearing loss, period. Just nothing, not doing it. And the Kaiser had said, look, the ACA, doesn't tell us what we have to cover, so we're just not doing it. And what the Ninth Circuit decided unanimously is that the ACA prohibits discrimination in benefit design. And so if Kaiser wants to say that certain services don't meet the criteria for hearing, don't meet its criteria, you wouldn't meet the criteria for any condition, that's fair. But they cannot say, hey, we're just not treating hearing loss because that's a civil rights violation. And we were anticipating, that's how we read the ACA. I submitted testimony to the feds on that years ago. That's how we read it. This is the first time a court has said we got it right. And what that would do, that just further backs up the argument that, it sort of adds to the federal mental health parity rules and it adds to the state mental health parity law, saying you simply cannot exclude treatment for developmental disability or autism or something like that. You have to provide reasonable coverage for it, period. So that just keeps building.
Yeah, and so like now, right, a lot of clinics are closed, and so, telehealth is becoming more of a thing and not less of a thing. Mm-hmm. And a lot of health services more broadly are moving, out of a clinic setting. Like the next front is schools, but I think at this point, like our position is that, if a clinician, if an ABA clinician determines that treatment in a particular setting is medically necessary, then, well, there you go. Insurance company doesn't get to second guess that anymore. That gets to second guess, the other details of the provision of care.
And that's really where, I need to get a better sense for how people are looking at the federal mental health parity statute. Can an insurer say, look, we'll treat your broken leg in the hospital. We're not going to go to the school to treat your broken leg. We're not going to go to your home to treat your broken leg. You come here for that. Therefore, you got to do that for ABA too. Another possibility would be to completely rewrite the statute and make it, we don't have a law, for instance, saying thou shalt cover cognitive behavioral therapy. There is no such statute in Oregon. We don't need one. We have mental health parity. What you could do is say, a plan that is covering applied behavior analysis services must provide coverage of services in home and community settings in addition to clinic settings. You could do something like that. And I think that would be a better statute. Whether we can get it passed or not is another question.
Yeah, I just kind of hate to introduce the concept of the insurance industry that, like they have any options here,
Yeah.
At this point, I don't really feel like they've got the ability to dictate, I don't know, so therapists, are you getting pushback from insurance companies based on, where or how or what or anything like that?
This is Megan. The only pushback I've gotten has been on school property, even when school's not in session or the client is not participating in school.
So is that from the insurance company or from the school?
The insurance company.
Okay. All right. Well, hell.
And that would sort of bring us to the strategy of keep the bill in place and delete the sunset clause, because it should be easy to pass. And then we have all of that, and we can just go fight it all out in the courts.
Yeah. Yeah, that might just make sense. That's, bad stuff in the bill is, I think everybody's accepted it, that it's unenforceable, and then we've got something in law saying that, you can't dictate the location of service.
Right. So, and that's, so again, it's a complicated question because, the other issue that came up about this is there's a provision in the bill that gives a very specific list of who was allowed to make a prescription for ABA services to get insurance coverage.
Right.
So, an issue arose because there exists I'm forgetting the specific title, there exists a nurse. It's a particular type of nurse, I forget the exact title for it, who happens to be highly trained and capable at diagnosing autism. And yet, she cannot give a prescription for, as she reads the law, as some insurers read the law, she cannot give a prescription for ABA because she's not included in our statute. Now, as I have pointed out to her, and federal mental health parity trumps that, so it just doesn't matter what the law says. But, that brings us into this whole long business of, great, now we have to go and either get the insurance commissioner to do something or get a court order, and, it's another $1 million down the drain. So wouldn't it be better if state law was actually legal?
So did anybody else have any questions for Paul? Or comments?
Just the specific question, the second thing I listed was about just miscellaneous updates to regulation of licensed behavior analyst. Does anybody have any concerns, comments about that, like either anything that I listed that shouldn't be done, or anything else that's missing that should be added to that list?
Ms. Brenna, looks good to me.
So for the staff, as I did a couple of years ago, if I can get your technical assistance in making sure that we write this correctly, that would be helpful.
Yes, absolutely.
In a way that doesn't harm your operation.
Yes, absolutely. We're always here for that. Just when you're ready, Paul, just get in touch with me.
Okay, great.
So this is Brenna. I'm now remembering, like, some meeting ago, 2 meetings ago, staff, you guys, so you were going to talk to the psych board and send out letters saying, by the way, remember, you've got to have a license to do stuff. Was that last meeting, and if so, did it get derailed by COVID, or?
So
am I hallucinating?
Oh, no. I wrote it down. I'm like, didn't we deal with this already? And I can't remember off the top of my head. So I have it written down on my little notepad because I'm like, same as you. I'm like, didn't we already deal with this? But I don't remember. So I have it written down as a note of to do. If we have not done it, we will do it. If we've done it, then we'll make sure and send it out again.
When I discussed it with the psych board, you're bigger than they are now. It is basically their problem, right? I mean, you counting the interventionists, you regulate more people than they do. And they're just frightened about their budget if they were to actually directly get involved with enforcing unlicensed ABA. And I think they would be willing, for instance, to send friendly warning notes to people saying, hey, you really need to get your ABA license, go talk to them. They just don't want to get in the business of investigating because it's just too much money for them.
Yes, I agree with you, Paul. That's why I wrote it down, because I'm like, I thought we already dealt with this, but God knows. I get obviously way too many things on my head, so I wrote myself a note, though.
Great, thanks.
Does anybody have anything else for Paul? Because we do have another person who's on the phone.
No, thank you.
Okay. Michelle. Oops, sorry. Thanks, Paul. Michelle, are you still on the phone?
Yeah, I'm here.
All right, Michelle. Did you have any comments that you wanted to make?
Yeah, I just wanted to introduce myself.
Yeah, introduce yourself first.
Yeah, no problem. I'm a licensed behavior analyst here in Oregon and obviously participating just as a participant in this meeting. I want to start off by saying just thank you to the board for having these open to the public to attend for individuals like Paul and myself and just be able to be really involved in our licensing board. I appreciate all the work that everyone's doing to support the field of ABA. And as you know, our field is growing exponentially and will probably continue to grow in that manner. And so I think getting more and more involved in regulation and guidance is really important. The only comment that I want to add is just to let the board know that I do have a lot of experience in the field of severe behavior for many years. I've used restraints in a very thorough, thought-out, well-regulated manner for multiple years, and I'd love to coordinate with the board if there's anything that I can do to help in that process. I do think that creating a general rule is really important that each agency is held to, even if it's specifying that they each have their own written policy, something to really help the field of ABA make sure that we're using restraints in the most ethical manner. Other than that, I just want to say thank you again for letting me attend, and then thank you all for the work that the licensing committee is doing in our field. So thank you, guys.
Thanks, Michelle. Michelle, if you have any kind of documentation or research or policies or anything regarding restraints that you would like the board to review, you're welcome to send them to Ann Thompson. She's on our website. All of our names and emails and phone numbers are plastered all over our website. But if you go to the website and click on ABA, If you scroll all the way to the bottom, and it will say Policy Analyst Ann Thompson, and gives her email and phone number and everything. But if you have anything you want the board to review, just email Ann. She'll make sure the board gets it.
Fantastic, will do. Thank you so much.
You're welcome. And is there anybody else as the public member who's on the phone that I missed earlier? Okay, awful quiet. Other board business. We are on the new number 7 or number 9, whatever, because we deleted 7 and 8. Other board business. So is there anything else that anybody wants to talk about? I think we've covered quite a bit today. We've got some things for the agenda for January. Like I said, anything relating to restraints whatsoever, get it to Ann. She'll make sure it gets out. But is there anything else that anybody wants to talk about?
This is Megan. I just wanted to reach out and see if anyone on any side on the board has any, is wanting, in regards to what's happening with telehealth and getting RBT certified or telehealth services in regards to the clients that we're serving right now, and see if there's anything that we want to do as a board in regards to those kind of things, or that we put on agenda for another meeting.
Hey Megan, this is Corey Stump. Thanks for bringing this up. I have a question, just generally speaking, if it's something that would be within our abilities as a board. We had attended a meeting through Washington. My agency had attended a meeting through Washington State Department of Health. And at that meeting, they had identified that in the state of Oregon, in the state of Washington, it was decided that no ABA services can be conducted via telehealth at all. Even if an insurance provider says, yes, you may provide telehealth to our members, the state of Washington is saying, no, you may not. So I'm not sure if it's something that the BARB can do to weigh in and possibly write a letter or something of that sort to the state of Washington, asking perhaps how they came to that decision, and why the differences across Oregon and Washington might be so vastly different, or might be so vastly on opposite decision-making processes for that specific topic. So that's just my little 2 cents I wanted to add, and see if that's something that might be a possibility.
So this is Sylvie. The communicating with the state of Washington and asking them why they made the decision that they made would be more of an association or a personal thing. It is not this board's responsibility. Their licensing and regulation is different, so that should probably come from somebody more like Araba and saying, hey, look, here's what Oregon does, and here's what you're doing. Why are you doing it different than Oregon? But that's not that's not the duties of the board.
Thanks, Sylvie.
No problem. And I'm not trying to discourage you guys from finding out your answer. It just needs to come in a different route.
Yeah, absolutely. And that was my question, so I appreciate it.
Sure. So, because we do allow, you guys know that we do allow for things to be done over the phone or in live. You do not have to be in person, but it has to be live, right?
And HIPAA compliant.
Is there anything else? I'm sorry I'm trying to stop cutting you off. Sorry.
This is Megan, and I know at the beginning we were struggling as an organization getting new RBTs or new BAIs certified with the state of Oregon, because we weren't, a lot of families weren't allowing the staff to go in home because they didn't want somebody new that wasn't going to work with their kiddo to come in for the purpose of providing the assessment. I know that's something we were struggling with initially, that was making it really hard to bring new staff on so that other families could get services, because oftentimes when we're bringing a staff on. We have to get them through the process, and then once that process is done, then we set them up with a family. So the family that they might do the assessment with would not necessarily be a family that they would be working one-on-one with. I know that was a struggle initially. I don't know if anyone else ran into problems like that.
Megan, do you have any center-based services?
No. We're home and community only.
Can you do anything by telehealth, certain items on the assessment?
That's where we were struggling is the definition of a client within the Oregon BII rules is that it said it needed to be someone with that we would provide services with. So it couldn't be, a family member or another adult or something like that.
Okay.
So this is Sylvia. I think another thing too that several different offices and agencies were having issues with is when they were hiring new individuals and those individuals were trying to get a license through us. One of the things that they have to do is have a fingerprint-based background check done. And a lot of the field print offices, so if anybody has questions on the process, please let me know, but a lot of the field print offices were closed due to COVID-19, and people were asking us, well, how else do I do that? So if anybody has any questions or needs help with that, we understand that field print offices may be closed. However, that is not the only way that an individual can get their fingerprints done. So if any of you or anybody you know is having issues because they can't get their fingerprints done, have them contact the office because we can give them some more details on that one too. You guys are awful quiet. Is there anything else anybody wants to talk about? Even more quietness. Okay. Megan, you should have a script to adjourn on your, should be at the last page of your second page of your scripts.
Yep. The Behavior Analysis Regulatory Board meeting is adjourned at 10:41 a.m.